Well, hello everyone, and welcome back to AJ111. This will be part 2 of chapter 3. So remember, we were talking about uh, searches and seizure, and we had left off with plain view. We had just finished up our discussion on informants and electronic eavesdropping, etc. And just kind of by way of summary to kind of get us started, remember in summary that the individual assumes the risk that the person with whom we are communicating with may be working as a government agent or informant, or they may just tell people. There really is no constitutionally protected expectation of privacy in conversations that we engage in with other individuals in those circumstances. And keep in mind also, it makes no difference whether the other individual is an informant or a government agent who um, immediately reports the contents, records the the information using electronic equipment, or transmits the conversation to police who are actually monitoring the situation. So all three of those are applicable. So now let's move on again. We're talking still under searches, and we're going to talk a little bit about plain view. Now, plain view is another exception to the Fourth Amendment warrant requirement, and it allows police to seize an item without a warrant under two conditions. All right, and they both have to be met. The first one is that the officer is legally situated, meaning that the police officer is lawfully there, that he or she has the right to be where he or she is situated. And the second part is probable cause. And this is where the police officer has probable cause to believe that the object is evidence of criminal activity. Now, the probable cause must be immediately apparent upon observing the item. So you have to recognize it, let's say, as contraband immediately, right? And then that meets the plain view requirement that we're talking about as we move through this a little bit. And the case that kind of oversees, if you will, that talks about that immediately apparent requirement would be a case in 1987, and this is the Arizona versus Hicks case. And in this case, an officer had heard a gunshot and ran into an abandoned apartment. The officer saw a brand new stereo unit, and he moved it in order to read the serial numbers. He called in the serial numbers, and the stereo was found to be stolen. So what do you think about that one? Let's kind of talk about that for a second. What do you think is it considered plain view based on what I actually just told you? Well, the Supreme Court in this particular case, and we'll talk about it a little bit more, agreed with Hicks that this was not a plain view search. Now, the officers were lawfully situated, but it was not immediately apparent that the stereo was stolen because the officer was forced to move the unit and to call headquarters in order to determine whether it had been stolen. And with that, the Supreme Court also recognizes a couple of other different types of searches, and we're going to look at that. So the Supreme Court, under the plain view doctrine, if you will, has recognized the plain field doctrine when patting down a suspect, where you conclude that he or she has encountered narcotics or a weapon or something similar. And other courts have recognized what we call a plain smell doctrine, when an officer smells narcotics or alcohol in a car. And some courts have also recognized a plain hearing doctrine in those instances in which individuals have no reasonable expectation of privacy and their conversations might be overheard by an individual. So again, the example I gave before, let's say that you are sitting at a restaurant and you overhear something. There's no real expectation of privacy with all of those other people there. So that's another exception to that. So hopefully that makes sense. And to kind of show you, because sometimes looking at things would be a little bit different. We talk about plain feel. You look at the outline of what appears to be a firearm stuck in somebody's pants. If you were to pat that person down and you can feel the object through your training and experience, you know what the outline, the shape of a firearm feels like. Okay. Again, the plain smell, where you can smell alcohol, you know what alcohol smells like, or you know what marijuana smells like, or you know what chemicals, precursors to methamphetamine might smell like. So you have the plain smell. And then finally, the last one that they talked about that, would be the plain hearing. Again, and that kind of goes into play, not just listening, where you might overhear somebody's conversation and there's no expectation of privacy, but maybe you hear a gunshot, and in the prior case where they ran into the home, so they were legally okay to go inside on an emergency basis, but again, when they had to move the property, it was found to be a violation of the plain view doctrine. So some other areas of expectation of privacy that we're going to talk about. So the U.S. Supreme Court has divided the home and the land surrounding the home into basically three separate categories with differing degrees of expectation of privacy and Fourth Amendment protection. And we're going to talk about three of those now. We're going to talk about open fields, we're going to talk about your home, and then we're going to talk about curtilage. So real quick, and let me give you the definition of each one, I guess, would probably help. The open fields, this includes land that is distant from the home, which the police may enter without probable cause or a warrant. Now, the home is the physical structure of the dwelling house, and it is afforded full and complete protection under the Fourth Amendment, and to enter it, the police in most instances will require a search warrant founded upon probable cause, or, there's always consent, but we'll get into that a little bit later. And then finally, the last one is curtilage, and this is the area immediately surrounding the home, and that's considered part of the dwelling house. And the curtilage has no expectation of privacy other than, from aerial surveillance. So aerial surveillance is going to be okay, but again, and these are all tested cases. Now, there are three other categories of property that we're going to look at, and each lacks an expectation of privacy under the Fourth Amendment, and we'll get to them. But that would be public property, commercial property, and then abandoned property. But we're going to spend a little bit of time on each one of these as we kind of go through. So the Supreme Court, when we talk about open fields, explained that there are good reasons why open fields are not protected by the Fourth Amendment. The Fourth Amendment is, remember, the purpose is that it's intended to protect intimate activities. There is no interest in protecting the types of activities that typically take place in open fields. And as far as access goes, open fields are more accessible to the public than are houses or offices. And again, they are easily monitored from aircraft. So that's the open fields. The curtilage, well, this is, again, as explained, this is the immediate area, sorry for the typo, surrounding the home, and it's considered part of the home itself. And this includes things like patios or decks or porches. And as a practical matter, how can an officer distinguish curtilage from open fields? Well, distance can be one. The area is distant or close to the home. That'll be something to look at. Or enclosure, meaning within an enclosed surrounding the home. So think about the case at the very beginning that we looked at. Do you remember what the case is? With the garbage at the curb. Does anybody kind of recall which one that one is? So that would be the, Greenwood case. We talked about that one a little bit. Do you believe that when someone takes their trash down to the curb, is that outside of the curtilage of the home, as opposed to if it was in the home's driveway? So just think about those things as we talk a little bit more. So again, curtilage is the immediate area surrounding the home itself. It's considered part of the home itself. It includes the patios, decks, porches. As a practical matter, again, how can an officer distinguish curtilage from open fields? Well, we talked about two of those, be distance and enclosure. Function, used for normal activities. That could be another sign, if you will. Or protection, effort made to protect it from observation, like a big 6-foot block wall. Okay, so that could be the protection, that somebody took the effort to protect that particular area. So curtilage is viewed, again, as part of the home. It has a high expectation of privacy. And the general rule is that a warrant is required for the search of a home or curtilage. Now, in another pretty landmark case, in the case of California versus Seraglio, the police received information from an informant that this individual was growing marijuana in his backyard. And Seraglio, in this case, had surrounded his home with a 6-foot outer fence and then a 10-foot inner fence that prevented investigators from investigating the tip, basically being able to kind of see through because the wall was so high, if you will. So what do you think about that? And the police in this particular case, they refused to be discouraged. So 2 trained narcotics officers flew a plane within navigable airspace at 1,000 feet, and in the air they observed marijuana plants in his backyard, took a photograph, then obtained a search warrant based on the photograph, and seized the plants. Now, Seraglio claimed that the officers had violated his reasonable expectation of privacy. What do you think? I don't want to take a lot of time here, but what do you think about that? It's a super interesting case. So in that case, though, the U.S. Supreme Court had held that in an age in which air travel is fairly routine, it is unreasonable for the defendant to expect that his marijuana plants are constitutionally protected from plain view observation with the naked eye from an altitude of just 1,000 feet. So Seraglio did not possess a reasonable expectation of privacy, and the police officers were not required to obtain a warrant to conduct aerial surveillance. So interesting. Well, what about this? What about a fence? Now, I show you the picture with the knot hole. So what if that knot hole that you're looking at wasn't poked through? It was actually filled. The knot was in there. And when you look, you couldn't see anything in the backyard. But what if the officer poked out the knothole? Could that be basically a violation of the Fourth Amendment? Think about it. It's all super interesting stuff. So again, warrantless aerial surveillance of the curtilage does not violate an individual's expectation of privacy. Even vision enhancement, such things as binoculars and precision cameras, when used for aerial surveillance, do not violate the Constitution. Okay, and we have those now. But what about drones? See how the Supreme Court's going to have to look at different things because now we have drones. And if you're to kind of finish up the curtilage part, this is a kind of a crude drawing, if you will, but it shows you the curtilage and what I mean. So out here, even if there's a sign that says no trespassing, if this is all open, then law enforcement it's admissible. If they see something, they can come in here. If they believe it to be contraband and it's immediately recognizable, etc. Now, the difference here is the curtilage. Remember, we talked about an expectation where they're trying to show that you're showing privacy. It could be a fence. It could be a wall. This walkway, your patio, this is all the curtilage. And that is not admissible. So hopefully that visual kind of helps you a little bit. So let's look a little bit more about technology, because we know that there's going to be more technology. And search warrants and arrest warrants, again, generally are required to enter into a home, which has the highest expectation of privacy. Well, what about this case? What about the Kylo versus United States case? Now here, the U.S. Supreme Court confronted the question of whether police may use a thermal imaging device without a warrant to measure the heat emanating or coming out of a house. And the theory behind the use of thermal imaging is that an unusually high degree of heat or warmth could provide law enforcement with probable cause that heat lamps are inside of the home and they are being used to grow marijuana. So what do you think about that? That's kind of a really cool, interesting case. And I'm going to let you kind of stew on that one a little bit and decide whether or not you believe that this is something that is okay, or if it's not okay. And again, as we have seen, the Supreme Court has upheld the employment of recording devices, aerial overflights, and even photographic technology to enhance surveillance. In the decades to come, we're likely to see new and even more powerful technology and different techniques of criminal investigation. And to help with that, the Supreme Court has adopted a couple of general rules regarding police technology. But I have a link to the Kylo case if you want a little bit more information. And the two rules in this particular case would be, when we talk about plain view, technology may be used to enhance observation of an area or object already in plain view. As it relates to home, the physical structure of a home possesses a higher or high expectation of privacy. Therefore, technology may not be used without a warrant to view what otherwise could only have been viewed from inside, in the sense of, if you look at the Kylo case, I kind of gave it away. They were not allowed to use the thermal imaging thing because it was to view the heat sense without a warrant, what otherwise could only have been viewed from inside. So hopefully that kind of makes sense to everybody. So let's look at a couple of other things really quick, and then we're gonna move on and finish up. So again, under a couple of rules, what do you think, constitutional or not? Can officers or law enforcement use a flashlight to illuminate people or things? Would that be a violation of the Fourth Amendment, an unlawful search or seizure? I'll give you a second to kind of think about that. If you said no, you are correct. It's not a violation. You can illuminate things to see better for your safety, etc. So that's okay. What about a GPS tracking of a car? Putting a tracker on somebody's vehicle? Do you think you're going to need a warrant for that? Or can you just walk up to somebody's car and stick a tracker on it? How about cell phone tracking? There's a really famous case dealing with cell phone tracking. It's Carpenter versus United States. And we'll talk about that in a couple of other case laws as we kind of go through this. But in both of these, the GPS and the cell phone, you're going to need a warrant in order to do both of those. And a little bit more to kind of back this up. So GPS monitoring of individuals, not necessarily cars, but of people. So here we have an individual by the name of Tory Dale Grady. He was convicted of second-degree sexual offense in 1997 and of taking indecent liberties with a child in 2006. Now remember, different states have different phrasing for different types of crimes. Now, following his release from prison, a hearing was conducted before a North Carolina Superior Court, and the court in this case ordered Grady, a two-time sex offender, to wear a GPS monitor at all times for the rest of his life. Let that one sink in for a second. And I have a link to the case if you really are interested in looking at that. But can we really have somebody wear that for the rest of their life? Again, super interesting case, but I'd really like you to kind of think about it. And when you look at it a little bit more, here, the Supreme Court, when they got this case, they held that whereas here the government obtains information by physically intruding on a constitutionally protected area, the Fourth Amendment search has undoubtedly occurred. The case was remanded for the North Carolina court to determine the reasonableness of the search based on the totality of circumstances, and you can kind of ask yourself, what's your view? Is this okay or not? Because if we have that on that person, we know where they are all the time, and that might be okay for a certain amount of time, but all of your life. So just think about those. And if you don't know what a GPS monitor is, they come in all shapes and sizes, and they are okay to a certain degree. But I think the bigger question here is for the rest of your life. All right. In another very important case, Florida versus Harris talks about not necessarily technology, but using canines to determine whether or not officers can develop probable cause if they get an alert from a canine. I have a link to the case there, and I'd really like you to take a look at it because it is another very important case. And I can't remember if it's one of your case studies or not, but a pretty interesting Supreme Court case. And you can actually look at some of that, I believe. I'm trying to find it for you right now. Florida versus Harris. You can find a little bit of the case on page 68 and page 69 in your textbook. So there's the Florida versus Harris case. So now what about public places and private business? So police may seize items that they observe in public places, including private businesses that are open to the public. A warrant, however, is required for the police to enter into portions of the business that are typically not open to the public, like employee offices or areas that are marked employees only, those typical types of areas. Abandoned property, well, this is the last thing that we're going to kind of discuss as far as property goes, and then we're going to move into actual persons. But it's described as that which an individual intends to abandon and physically abandons. So there is no Fourth Amendment protection here. And the judge or the judges, in looking at whether property is abandoned, they rely on the totality of circumstances. And some of the things that fit in there are where the property was found, the condition of the property, the type of the property, and then there are some other factors that kind of go along that. So hopefully that kind of makes sense. So an individual has no expectation of privacy in abandoned property, and the property has no Fourth Amendment protection. So as a result, police are not required to get a warrant to examine and even take control of the property. And property typically does not carry a sign indicating that it's abandoned, so that's why the judges have to rely on the totality of circumstances and consider these 4 different factors. Now, if you go back to the very first case that we looked at, California versus Greenwood, that was one of the factors. Not only was the trash outside of the curtilage of the property, but it was also found that typically people, again, when you're using totality of the circumstances, people, when they take their trash to the curb, it's meant to get rid of it. You're not meant to keep it anymore. Therefore, the justices decided there was no expectation of privacy when you took your trash down to the curb. So this abandoned property piece also fits into that particular case law. Okay, so now we're going to talk a little bit about people and the seizure of persons. So the drafters of the U.S. Constitution were concerned with protecting persons as well as their houses, papers, and effects from unreasonable search and seizures. And we know that in the Fourth Amendment, or under the Fourth Amendment, a seizure occurs when a law enforcement officer detains a person and restricts them of their freedom of movement. And when you look in your textbook, there's a table 3.2 on page 74 that gives you a little bit more information on that. So the U.S. Constitution, again, is intended to promote individual freedom, and it limits that freedom only to the extent required to protect safety and security of society. So the Fourth Amendment seizure follows a very simple formula that we will develop in detail, not just in this chapter, but as we talk about some other chapters. And basically, the greater the interference with a person's freedom, the greater the factual burden that must be satisfied by law enforcement to justify the stop. So again, a seizure of a person occurs when a law enforcement officer detains a person, and the greater the interference with that person's freedom, the greater the factual burden that must be satisfied in order for law enforcement to justify that particular stop. And there are typically 3 types of police-citizen interactions. Now, there are others depending upon what textbook you're looking at, but for this lecture, we're going to talk about an arrest, a stop or a detention, or an encounter, which is also known as a consensual encounter. Now, an arrest of an individual that may result in the person or persons being taken into custody and the accompanying search incident to arrest for weapons or contraband requires probable cause. So remember, we talked about the different levels of burden. Now, in contrast, a brief investigative stop of a person may be based on less demanding standard, that less demanding standard being reasonable suspicion, and permits only the protective frisk of a person's outer clothing for weapon. And the Supreme Court has also, again, recognized a third category of police-citizen interaction that law enforcement professionals refer to as encounters. And I call them consensual encounters because these are non-coercive, voluntary contacts between police and citizens that are not regulated by the Fourth Amendment because there's no detention. The court has observed that not all street contacts between citizens and police constitute a seizure. Therefore, there are any number of casual interactions on the street, in a park, in a restaurant that don't restrain somebody's movement. So hopefully that makes sense. And they base all of these on whether or not it was an arrest, a stop, a detention, on a case called California versus Hodari, and it is the totality of the circumstances. So hopefully those police-citizen interactions make sense. And again, as we learned, I believe, from chapter 1, there are different burdens of proof. And we're not talking about all of these right now. We're talking about the lowest one, reasonable suspicion, which is where you need to be able to specify, be specific, and articulate some facts that you believe that something is taking place, some type of criminal activity is taking place, and you want to investigate further, but you have to be able to articulate it. Probable cause is the next level up, where facts and circumstances lead an ordinary person to believe that this person has committed a crime, or is the person that you're looking for, or is armed and dangerous, etc., which means that you can search them and you can arrest them. That's probable cause. And then we'll get to some of the other ones as we start to move on. And that's why they have them in kind of this pyramid. So again, when we talk about consensual encounters, the mere fact we're speaking to somebody does not constitute a seizure. It happens all the time in an officer's day-to-day routine. So there is no Fourth Amendment violation because there's no detention because the person is free to leave. Unlike some other situations where maybe you've been pulled over for a traffic ticket or a traffic violation. You're not free to leave until the investigation is done. Okay, if somebody's going to check you because they believe that you're armed, you're being detained and they can frisk you. Okay, or if you're a wanted person and they're pointing their firearm at you. So these are, or the officer tells you to stop, that becomes a detention. That's no longer a consensual thing. So again, we can go back and we can review those. There's an arrest, there's a stop or detention, and then there's a consensual encounter. And the arresting part would be obviously when you're taken into custody or you are well aware that you are going to be taken into custody based on the actions of the law enforcement officer. So when is an individual actually seized then under the Fourth Amendment? So again, courts analyze the totality of the circumstances to distinguish a seizure from an encounter. And the distinction at times can be a little bit unclear. Consider whether Sylvia Mendenhall's interaction with federal agents was a seizure or an encounter. In this case, U.S. versus Mendenhall, 2 federal drug agents approached Mendenhall in the concourse of the airport in Detroit. They identified themselves and they asked to examine her driver's license and airline ticket. The ticket was issued in the name of Annette Ford. The agents also noticed that Mendenhall appeared to be shaken and nervous and had difficulty speaking. The agents returned Mendenhall's identification and ticket, and she agreed to accompany them to an office 50 feet from where they were originally standing. Now, once inside, she consented to a body search, which resulted in the seizure of heroin. So kind of an interesting case. So here the Supreme Court held that this was not a Fourth Amendment seizure. And as a result, the officers were not required to establish either probable cause, as that's what they would have needed to arrest her, or reasonable suspicion to frisk her to justify their decision to approach her in the first place. Because you can walk up to anybody, again, and engage in a conversation. So again, when is an individual seized under the Fourth Amendment? There are two types of seizures. The first is a physical seizure of a suspect and a show of authority seizure, in which police officers restrain individuals through the display of authority without the actual going hands-on physical force. Remember, a seizure requires a showing of either probable cause or reasonable suspicion. Because just because you're detaining somebody doesn't mean that you're going to arrest them. So by definition, physical seizure, taking physical hold of a person. Show of authority seizure demonstrates their authority by directing, displaying, blocking, or other conduct that would lead a reasonable person to believe that they are not free to leave. Okay? All right, so I think we made it through. I hope that that wasn't really too long. I broke it up into two different pieces, but I think we needed to with the amount of context. So just, I think it was important that we did that. All right, so that will conclude our lecture on Chapter 3, Searches and Seizure. Don't forget to do the key terms matching self-assessment. It's the non-graded exercise you can find in the module that will help you learn a lot of the definitions. And then also don't forget about looking at some of the chapter questions. At the end of each chapter, there are 4 or 5 discussion questions that I think if you looked at them and you tried to understand some of those questions, it will also help add a little bit of context to what we've been talking about. So with that being said, again, concluding the Chapter 3 lecture, and until next time.